On the afternoon of July 20th, 1925, in the Tennessee courtroom so crowded the floor was beginning to sag, one of the most famous lawyers in America called the prosecuting attorney to the witness stand. The lawyer was Clarence Darrow. The witness was William Jennings Bryan, 3 times a candidate for President of the United States, former Secretary of State, and the most beloved religious orator in the country. Darrow was not going to question him about the law. He was going to question him about the Bible. The charge against the defendant was almost an afterthought. A young schoolteacher named John Scopes had taught a chapter on human evolution to a class of Tennessee boys. But what was actually on trial that week was something much larger: whether a state could write its scripture into its science books. This is the state of Tennessee versus John Thomas Scopes. To understand the trial, you have to understand that almost nobody in Dayton, Tennessee actually wanted to punish John Scopes. The trial happened because the town invited it. In March of 1925, the Tennessee legislature passed a statute called the Butler Act. It made it unlawful for any teacher in a state-funded school to teach any theory that denied the divine creation of man as taught in the Bible, and to teach instead that man had descended from a lower order of animals. The new law carried a fine of up to $500. The American Civil Liberties Union, a young organization in New York, saw the Butler Act and decided to fight it. But they needed a test case. They placed an advertisement in Tennessee newspapers offering to defend, free of charge, any teacher willing to be prosecuted. A group of Dayton businessmen read that advertisement in the back of a local drugstore. The town was small, sleepy, and economically flat. One of the men, an engineer named George Rapelier, said out loud what the others were thinking. A famous trial would put Dayton on the map. They sent for John Scopes. He was 24 years old. He was not even the regular biology teacher. He was a part-time science instructor who mostly coached the high school football team. He had filled in for the biology class for 2 weeks when the men asked him whether he had taught evolution from the assigned textbook. Scopes told them the truth.
I taught from the book the state itself put in the schools. It has a chapter on evolution in it. If teaching that page is a crime, then I suppose I am guilty of it.
Scopes agreed to be arrested. A warrant was sworn out that same afternoon. And then, while he waited to be charged, John Scopes went and played a game of tennis. The most famous defendant of the decade was, by his own account, almost a bystander at his own trial. A small misdemeanor in a small town should have ended with a small fine. Instead, within days, the case attracted the 2 largest personalities in American public life. For the prosecution, William Jennings Bryan, 3 times the Democratic nominee for president, former Secretary of State under Woodrow Wilson, the man who at 36 had electrified a national convention with a single speech about a cross of gold. By 1925, Bryan had become the leading public defender of fundamentalist Christianity in America. For the defense, Clarence Darrow, 68 years old, the most famous trial lawyer in the country and its most famous courtroom skeptic. He had spent his career defending labor organizers, anarchists, and the condemned. 1 year earlier, he had saved the teenage killers Leopold and Loeb from the gallows. Darrow was, by his own cheerful admission, an agnostic. He volunteered for the Scopes case without a fee. The town of Dayton, population 1,800, suddenly hosted 200 newspaper reporters. Telegraph wires were strung directly into the courthouse. Loudspeakers were mounted on the lawn. A Chicago radio station, WGN, ran cables to broadcast the proceedings live. The first trial in American history carried on the radio. Vendors sold sandwiches and toy stuffed monkeys. A live chimpanzee was brought to town and reportedly seated at a downtown soda fountain. Street preachers set up on every corner. The national press had already named it. They were calling it the monkey trial. The trial opened on Friday, July 10th, 1925. The courtroom on the second floor of the Rea County Courthouse was the largest in the state, and it still could not hold the crowd. Roughly 1,000 people packed a room built for far fewer. The temperature inside passed 100 degrees. On the bench, Judge John T. Raulston, a circuit judge from the Tennessee mountains, devout, courteous, and entirely unprepared for the largest audience any American judge had ever faced. He arrived each morning carrying his Bible on top of his law books. At the prosecution table, William Jennings Bryan, his son, Bryan Jr., and the man who would do the real legal work, Tom Stewart, the young Attorney General of the circuit. At the defense table, Clarence Darrow, the New York attorney Dudley Field Malone, and the constitutional lawyer Arthur Garfield Hayes. Judge Raulston opened each session with a prayer. The defense objected to the prayers. They were overruled. And then, before a single witness was heard, Clarence Darrow stood up to argue that the entire law was unconstitutional. Darrow's opening attack ran nearly 2 hours. It was not a folksy country speech. It was a cold, exact, and furious argument that the Butler Act had married the state of Tennessee to one specific religious doctrine.
Here's a country that for 150 years has boasted of its freedom. And here's a law that says what a teacher may say and what he may not say about the origin of man. If today you can take a thing like evolution and make it a crime to teach it in the public schools, tomorrow you can make it a crime to teach it in the private schools. And the next year, you can make it a crime to teach it from the pulpit. Ignorance and fanaticism are ever busy. After a while, Your Honor, it is the setting of man against man and creed against creed until we are marching backwards to the glorious age of the 16th century.
When Darrow finished, the courtroom was silent. A correspondent for a Baltimore newspaper, a sharp-tongued writer named H.L. Mencken, reported that the speech had stunned the town. But Darrow had not come to Dayton to win on the law. He suspected, correctly, that he would lose every legal motion. He had come for something else. The defense strategy was unusual, and it was deliberate. Darrow's team did not seriously argue that Scopes had not taught evolution. He had. Everyone knew he had. Instead, the defense wanted to put on the stand a parade of expert witnesses, scientists and theologians, to testify that evolution was sound science, and that it did not, in fact, contradict the Bible. The prosecution understood the danger immediately. If the jury heard days of distinguished scientists calmly explaining evolution, the trial would stop being about a broken law and start being about whether the law made any sense. So Tom Stewart rose to block the experts entirely.
Your Honor, the question before this court is narrow. Did the defendant teach that man descended from a lower order of animals? That is all. Whether the statute is wise, whether evolution is true, whether it agrees or disagrees with the book of Genesis, none of that is on trial here. The opinion of a scientist from New York cannot repeal an act of the Tennessee legislature.
It was, as a matter of law, a strong argument. And Bryan, who had mostly stayed quiet, rose to support it with a speech that revealed what the trial meant to him.
The people of Tennessee have a right to say what shall be taught in their schools. The taxpayers of this state have a right to direct what their children are taught. And these gentlemen want to bring in scientists to tell this court that a law passed by the people's own representatives should not be enforced. The Bible is not going to be driven out of this court by experts who come 1,000 miles to testify that they can reconcile evolution with its ancestor in the jungle to man made by God in his own image.
The gallery applauded Bryan. And then Dudley Field Malone stood up for the defense and answered him. And what followed became the most famous speech of the entire trial.
We have not found the courage to bring the children of this generation face to face with the facts. We do not fear the truth. We are not afraid. Where is the fear? We meet it. Where is the fear? We defy it. We ask your honor to admit the evidence as a matter of correct law and as a matter of sheer, common, open justice.
When Malone sat down, the courtroom erupted. Spectators stamped the floor until the timbers shook. A bailiff broke a gavel trying to restore order. Reporters wrote that even Bryan privately admitted it was the finest speech he had ever heard. But applause is not a ruling. On Friday, July 17th, Judge Raulston gave his decision. He ruled that the expert testimony would not be admitted. The scientists could not testify before the jury. The defense had just lost the case it had planned to fight. What Clarence Darrow did next is the reason this trial is still studied 100 years later. He had been forbidden to put scientists on the stand, so Darrow decided to put the Bible on the stand instead, in the person of William Jennings Bryan. The defense announced that it wished to call William Jennings Bryan as a witness, as an expert on the Bible. It was an extraordinary request. A lawyer for the prosecution does not normally testify in his own case. Tom Stewart objected at once. He could see the trap.
Your Honor, I object. This is not proper. Mr. Bryan is counsel in this case. What possible bearing can his personal views of the scriptures have on whether this young man taught a chapter out of a biology book?
And then William Jennings Bryan made the single worst decision of the trial. He waved off his own lawyer. He wanted to do it. He had spent his whole life defending the Bible from public platforms. He believed he could not lose on his own ground.
I am not afraid to get on the stand in front of him and let him do his worst. I am simply trying to protect the Word of God against the greatest atheist or agnostic in the United States.
I object to your statement, Your Honor. I am examining you on your fool ideas that no intelligent Christian on earth believes.
Because of the size of the crowd and a real fear that the courtroom floor might actually collapse under the weight, Judge Raulston made a remarkable decision. He moved the entire proceeding outdoors. The most famous confrontation in American legal history would take place on the courthouse lawn. On the afternoon of Monday, July 20th, 1925, benches were carried out onto the courthouse lawn. An estimated 3,000 people gathered under the oak trees. William Jennings Bryan took a seat in a plain wooden chair on a raised platform. Clarence Darrow stood in his shirt sleeves on the grass below him. And then Darrow began to ask questions. Darrow's strategy was simple and merciless. He did not attack religion. He asked Bryan, very politely, whether every story in the Bible was to be taken literally.
You have given considerable study to the Bible, haven't you, Mr. Bryan?
Yes, sir. I have tried to.
Then you have made a general study of it.
Yes, sir. I have studied the Bible for about 50 years.
Darrow started gently. He asked about Jonah and the great fish.
You believe that the big fish swallowed Jonah, or that the whale swallowed Jonah, and that he remained there how long? 3 days? And then he came out alive?
I believe in a God who can make a whale and can make a man and can make both do what he pleases.
Now you say the big fish swallowed Jonah. Did he swallow him, or just keep him in his mouth and let him out?
The crowd laughed. But the laughter was beginning to shift sides. Darrow moved on to Joshua, who in the Bible commands the sun to stand still in the sky.
You believe that at that time the entire sun went around the earth?
No. I believe that the earth goes around the sun.
Then the language we have there of the sun standing still was not strictly correct?
There it was. The hook. If the sun did not move, then the Bible's plain words were not in that case literally exact. Bryan had just conceded in front of 3,000 people that at least one verse could not be read literally. And once he had conceded one, Darrow had him. Darrow kept going. He asked about the age of the earth. He asked about the date of the flood. He asked where Cain had found his wife. He asked whether the 6 days of creation were 6 days of 24 hours.
Do you think the earth was made in 6 days?
Not 6 days of 24 hours.
The crowd reacted. Because that answer from the greatest fundamentalist orator in America was itself an interpretation. A day that was not a day. Bryan was no longer reading the Bible. He was, in front of everyone, interpreting it.
Your Honor, I've objected to this from the start. What is the purpose of this examination?
The purpose is to cast ridicule on everybody who believes in the Bible. And I am perfectly willing that the world shall know that these gentlemen have no other purpose than ridiculing every Christian who believes in the Bible.
We have the purpose of preventing bigots and ignoramuses from controlling the education of the United States. And you know it. And that is all.
By the end, the questioning had become painful to watch. Brian was 65 years old, sweating in the heat, surrounded by a crowd that had come to cheer him and was now sitting in uneasy silence. His answers grew shorter. He admitted he had never read Darwin. He admitted he did not know the age of the earth, or how old the great civilizations of Egypt and China were, and that he had never troubled himself to find out.
I do not think about things I do not think about.
Do you think about things you do think about?
Judge Raulston. Watching the questioning collapse into spectacle finally stopped it. The examination of William Jennings Bryan had lasted roughly 2 hours. The next morning, the judge ordered the entire exchange struck from the record as irrelevant to the case. But it did not matter. 200 reporters had already sent it to the world. The trial ended the next day, Tuesday, July 21st. And it ended in a way almost no one expected. Clarence Darrow stood up and asked the jury to find his own client guilty. It was a strategic move. Darrow knew the local jury would convict Scopes anyway. But a guilty verdict could be appealed, and only on appeal in a higher court could the defense get a real ruling on whether the Butler Act itself was constitutional. By asking for conviction, Darrow gave up the battle to win the war.
We claim that the defendant is not guilty, but as the court has held that we cannot prove our case and cannot review it without a verdict, we do not see how this jury could do otherwise than find a verdict of guilty. We make no objection to that.
The case went to the jury. They did not even retire to the jury room. They stepped into a corner of the courtroom, conferred for 9 minutes, and returned.
Gentlemen of the jury, have you agreed upon a verdict?
We have, Your Honor. We find the defendant guilty as charged.
Judge Raulston turned to the defendant. For nearly the entire trial, John Scopes had not said a word. Now the judge asked him if he had anything to say before sentence was passed. Scopes stood up. It was the only real statement he made during his own trial.
Your Honor, I feel that I have been convicted of violating an unjust statute. I will continue, in the future, as I have in the past, to oppose this law in any way I can. Any other action would be a violation of my idea of academic freedom.
Judge Raulston fined John Scopes $100. It was the minimum the law allowed. The most famous trial of the decade ended with a fine smaller than the cost of a single day's telegraph wire. 5 days after the trial ended, on Sunday, July 26th, 1925, William Jennings Bryan lay down for an afternoon nap in a house in Dayton and did not wake up. He was 65 years old. The great commoner had outlived the trial by less than a week. 2 years later, in 1927, the Tennessee Supreme Court heard the appeal. It did something clever. It upheld the Butler Act as constitutional, but it overturned Scopes' conviction on a technicality, ruling that the judge, not the jury, should have set the fine. By reversing the conviction, the court left nothing for the defense to appeal to the Supreme Court of the United States. The constitutional question was simply left unanswered. The Butler Act stayed on the books in Tennessee for another 42 years. It was not repealed until 1967. 1 year after that, in 1968, the Supreme Court of the United States, in a case from Arkansas called Epperson versus Arkansas, finally ruled that laws banning the teaching of evolution violated the First Amendment because they existed to advance a particular religious view. John Scopes never taught school again. He took the scholarship money that supporters had raised for him, studied geology, and spent the rest of his quiet life working for oil companies in Louisiana and Venezuela. He almost never gave interviews. He had been from the first afternoon in that drugstore to the last, the calmest and least famous person in his own famous trial. The trial of John Scopes settled almost nothing on the day it ended. The teacher was convicted. The conviction was erased. The law survived. But something had happened on that courthouse lawn that a struck record could not undo. For 2 hours, in front of 3,000 people and the entire listening country, a question had been asked out loud. And everyone had heard how hard it was to answer. If you want to come with us to other courtrooms, to the treason trial of a former vice president, to the dock at Nuremberg, to the trial of Susan B. Anthony for the crime of casting a vote, subscribe to the highest court, because some trials are not decided by the verdict. They are decided by the questions a room full of people are finally forced to hear.